Major breaking news out of New Orleans, specifically the Fifth Circuit Court of Appeals. That's the United States Court of Appeals. For the Fifth Circuit, three-judge panel heard oral arguments this morning in the Vanderstok case, which is the so-called Joe Biden ghost gun regulation case, whether or not the ATF exceeded its authority by trying to regulate a whole bunch of items that are not firearms or not covered by federal statute. Stay tuned. We're going to break it down when we get back. Hey folks, I'm Mark Smith, host of The Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the book, First They Came for the Gun Owners. The book that lays out the entire battle plan of the anti-gunners in America, how they intend to take away our rights from A to Z. I put it together, First They Came for the Gun Owners. Check it out if you don't already own a copy. All right, folks, this morning, I live tweeted this out, and I have to say, if I look a little tired today, I had to get up extra early this morning because I also had Fox News. So I went right from Fox News to live tweeting the Fifth Circuit Court of Appeals argument on the so-called ghost gun regulation issue. And I'm happy to report the good news here, which is that despite the fact that I'm tired, it was clear even to me that the ATF is in huge, huge trouble. This three-judge panel literally lit up the ATF and their lawyer, who worked hard and made all the best arguments he could make, but it was clear that the judges were having none of this, and they thought the ATF was really out of its metaphorical mind to try to do what it was doing by regulating parts of frames or receivers and trying to take the phrase readily convertible and stick it in other parts of the law that it doesn't belong in and that Congress did not insert. So to begin with, let me tell you who the three-judge panel was. It's a very good Second Amendment panel as I see it. You had Judge Don Willett, former justice on the United Don Willett, former judge on the Texas Supreme Court, very good on the Second Amendment. You had Kurt Engelhardt, another strong judge, pro-Second Amendment, I believe. And last but not least is someone who we may actually see on the United States Supreme Court to the extent a Republican ever becomes president again. That's Andrew Oldham. Andrew Oldham is literally auditioning every day to sit on the United States Supreme Court if a vacancy were to arise. So we watched him very carefully, and I can tell you he acquitted himself fantastically. A great job by this entire panel, and a good audition for the Supreme Court if a Republican ever becomes president again for Judge Oldham as I see it. So let me tell you where this, to begin with, let's go back through what the issues are, and then I'm going to tell you what the judges said, because it was catastrophic against the ATF. The ATF was literally destroyed. At least that's the appearance, and I suspect that the opinion is going to be terrible for the ATF and the Department of Justice point of view. But let's get to that in 1 second. Specifically, just to jog your memory, several months ago, as you probably recall, Joe Biden issued these ghost gun regulations, and what he did was he expanded the definition of frame or receiver to include parts of frames and receivers on the grounds that parts of frames or receivers that were readily convertible into frames or receivers were the same as frames and receivers. The reason why this is important is because under federal statutory law promulgated by Congress, frames and receivers constitute firearms that have to be serial numbered and are firearms. But so what the ATF was trying to do here in the Department of Justice under Merrick Garland, that moderate, was to expand the definition of frame or receiver to include parts of frames or receivers that could be readily converted into frames or receivers. That was the first thing. The second issue was about weapon parts kits. Specifically, if you have parts of firearms but are not firearms yet, could they be readily converted into a firearm? And that went nowhere fast either. We'll get to that in 1 second. And the last issue is, what is the remedy? Specifically, should the court, if they rule against the ATF, enter an injunction, or should they enter what's known as vacatur, a very technical issue that's probably going to get a lot more play down the road. We'll get to that in 1 second as well. So the bottom line is this. Right from the start, the ATF went first because, as you remember, where this case came from is the federal district court judge looked at all the facts, looked at the record here, and said the ATF is clearly wrong, that this ghost gun regulation is made up. They have to go back to Congress to pass federal legislation, but there's no way that existing law allows the ATF authority to regulate quote-unquote ghost guns, which are really just, homemade guns, unserialized firearms. Moreover, the federal district court said that no, the authority of the Congress did not give the ATF and DOJ the authority to regulate partially created frames or receivers, partially completed frames or receivers, again, not protected or not allowed by the ATF. They're not covered under the statute, therefore the ATF can't regulate it. And likewise, these weapon parts kits, which are not weapons, those cannot be regulated because, again, Congress has not given the ATF this authority. So the district court entered a order known as vacatur. Now, to be really quick about this, under the Federal Administrative Procedure Act, if a court finds that an administrative agency has done something that exceeds its authority, meaning it acts outside of its statutory authority given to them by the Congress after enacting a law, then a federal court can say that, look, you administrative agency, whether it be the ATF, could be the DEA, could be the FDA, could be the EPA, any of these agencies, you've exceeded your authority under the statute. We are entering an order of vacatur, which means that we are vacating the rule, null and void, gone, goodbye, it's over. The reason why this is significant is because it means that the rule disappears nationwide as applied to all Americans. So the district court entered an order of vacatur, and then the Department of Justice took an emergency request or emergency motion to the Fifth Circuit Court of Appeals that said, yeah, we agree that the vacatur decision is appropriate in this context when it comes to how the ATF has exceeded its authority. So they basically affirmed on an emergency basis the vacatur decision entered by the district court. And then, this is the key, you may remember this, the Merrick Garland Department of Justice sought an emergency stay of the vacatur decision from the U.S. Supreme Court. And unfortunately, in a 5-4 decision, the Supreme Court, with Amy Coney Barrett and John Roberts siding with the liberals, entered an order staying the Fifth Circuit's vacatur decision, which means that right now, the so-called Joe Biden ghost gun regulations are in effect, and you have to comply with those. And to make matters even worse, the Supreme Court said that the stay of the Fifth Circuit's vacatur decision will remain in place until after there is a decision by the Supreme Court on this case, either the denial of cert or the granting of cert and a resolution by the Supreme Court, which literally will take 18 months or more. And what's more unfortunate is even if the Fifth Circuit ruled in our favor, which they're going to, I believe, and entered an order of vacatur literally tomorrow, Merrick Garland would be able to drag his feet and make it so that the rules would remain in effect for a year and a half. So obviously, that's most unfortunate, but that is the reality of the Supreme Court decision that stays the vacatur decision. Now, there may be a way around that, which we'll get to in a separate video, but for now, that is where we are. So with all that in mind, though, the Fifth Circuit has to make its decisions before it can get to the Supreme Court, and the Fifth Circuit made it very clear, as I interpreted their oral argument questions, that the ATF is a dead dog loser on this point. So just to give you an example of how bad it went for the ATF, in the opening questions from the court to the ATF's lawyer, Judge Oldman asked about a 1973 case out of the 8th Circuit Court of Appeals in Missouri. And what's shocking is the ATF basically embraced this rule. Now, the reason why I'm telling you about this case is because this is where the ATF views this notion of readily convertible. Specifically, the way the statute works is that if something is readily convertible into a firearm, meaning if you have a firearm in front of you and you just have to put it together, well, then that's readily convertible. That's a firearm. What they're trying to do is to try to say that language of readily convertible can be cut and pasted and incorporated into the second part of the statute that says that something that is readily convertible into a frame or receiver also constitutes a frame or receiver. Well, there's two critical things that came up in this argument today brought up by the court. The first is the court says, well, wait a minute, let me get this straight. I'm paraphrasing here. So you all know the statute of David, which actually I've talked about on this channel before, which is that very great marble statute created by Michelangelo. So basically what the court said is, so let's get this straight. So if you have a marble slab, that's just a marble slab, and someone with the skill set of Michelangelo could, in theory, chop up that and sculpt that marble slab into the beautiful statue of David, then you're telling me that marble slab is the statue of David because it can be readily converted into the statue of David by someone who's skilled, like Michelangelo. And that's essentially what the ATF is arguing. Now, that may sound crazy to you because this is an argument I flagged a few months ago about this notion of the statue of Michelangelo, the statue of David by Michelangelo, but it's not true. It's actually an argument ATF is advancing. Specifically, they rely on this Eighth Circuit case from 1973. Let me tell you why this is important and why it's somewhat shocking, and the court found it shocking as well that the ATF was relying on this precedent. What this case said, and I'll put a link to this case called United States versus Larry Smith. Basically, it was a case where a man was convicted in the 1970s for possessing a unserviceable Thompson machine gun. All right, there's no dispute that he possessed this, but he says, okay, but it's a worthless nothing. It doesn't work. So what's the big deal? Like, who cares if I have it? It doesn't work. And what the ATF did is they went out and they got, it was the ATF Department of Justice went out and got an agent. Maybe it was the Department of Justice got an agent that was able to readily restore, and this is what's so key, that it was able to readily restore this Thompson machine gun with expertise and all the right tools and a machine shop in 8 hours. And what the court said, and the ATF embraced, this is what the court said in 1973, the Eighth Circuit, quote, "The term readily restorable to shoot as used in the law, so whether a firearm is capable of being readily restorable to shoot is a matter of judgment." And it goes on to say that even if it takes a working day to restore it, and even if another way to do it would be to use someone, and here's the critical language, even if you can make this readily convertible into a fully automatic machine gun, this is the case was about machine guns, even if to do so would take about, quote, an 8-hour working day in a properly equipped machine shop, guess what? It's readily convertible into a machine gun in that case, and the ATF today was arguing that based on this precedent from 1973, if something could be readily converted into a frame or receiver or a firearm in a period of 8 hours with a fully equipped machine shop with someone that's sophisticated and skilled in the effort, that would indeed constitute something that is a firearm and or a frame or a receiver. Now, the court immediately pushed back on this and said, wait a minute. If this is the case, and this is where I think Judge Oldham is really auditioning for the Supreme Court, he pushed back and says, wait a minute. Now, we know that a semi-automatic AR-15, a basic AR-15 semi-automatic firearm, can be readily converted into a fully automatic machine gun with, messing around with a sear. Which, by the way, is an issue that I flagged on this channel before, where the anti-gunners are going to go, where they're going to claim that AR-15 semi-automatic rifles and firearms are readily convertible into NFA items because they're readily convertible with things like Glock switches into automatic firearms. And therefore, all these semi-automatic AR-15s are machine guns that need to be registered under the NFA. That is what I've been saying for some time. I'm glad that other people are now picking up on this whole game the anti-gunners are playing. And that is exactly what the Fifth Circuit picked up on today, because the question to the ATF was exactly that. They said, look, so are you telling me that the AR-15 semi-automatic rifle, because it can be readily converted into a fully automatic firearm in a lot less time than in the Smith case of 8 hours with a fully operational workshop? Are you telling me that that turns an AR-15 into a machine gun that can be registered because it's readily convertible or readily restorable? And the ATF lawyer, by my interpretation, was essentially humada, and did not have any kind of good answer to that. And it was clear that the judge just was, I wasn't there, I could only listen to it, but it was clear, metaphorically at least, that the judges were rolling their eyes, or at least you could kind of hear them rolling their eyes to be like, yeah, this readily convertible thing has got to be inserted by Congress or we're not going to incorporate it because it's a really big deal. They also thought it was just conceptually kind of absurd because anything can become converted. Again, by their definition, if something is readily convertible because by virtue of somebody spending 8 hours in a fully operational workshop to convert something into anything, well, anyone can convert anything to anything under those circumstances because an expert can take a whole day to do whatever it needs to be done, just like Michelangelo can, convert a slab of marble into the statue of David, but that seems to be an absurd standard. So on a related note, what came out in this, as I see it, with the back and forth, was that, and I think the court picked up on this, is the ATF did not want to draw a line. Specifically, they kept asking hypotheticals of the ATF lawyer, and the lawyer, frankly, did not do a clear job. I'm not saying he did a bad job, but I think he was not crystal clear in a lot of his answers. And the reason why I think he wasn't crystal clear may be because the ATF and the Department of Justice doesn't actually want clarity. And this kind of popped up as well, that some of the things that the ATF was really arguing today really suggested they wanted things that were vague and ambiguous. And the court really pressed the lawyers to say, look, if it's vague and ambiguous as to what falls within the definition of frame or receiver or firearm or not firearm or weapon, then how is an ordinary American to know whether or not they're complying with the law or not? And it certainly came across to me, listening to the argument, it's almost as if the ATF doesn't want Americans to know whether they comply with the law, because that will give rise to a chilling effect. People will be like, I don't know if I'm complying with the law or not, so I'm not going to do it. And that is a chilling effect on Second Amendment rights. And it seems to me that may be a feature and not a bug, based upon the impression I got, not just from the lawyers for the ATF, but also the way the colloquy went back and forth with the judges. The judges seem to have picked up on this as well today at this argument. All right, so let me summarize what's going to happen. I think the Fifth Circuit is going to issue a 3-0 decision against the ATF. They're going to say that the ghost gun regulation dealing with an attempt to regulate things that are partially completed frames or receivers is going to go down in flames. That is going to lose. The ATF is going to lose big on that, and I think they should. As to the weapon parts kit, I think they're also going to lose big on that, and this is the argument that sort of went back and forth with the court, and I think the court seemed to be willing to embrace it, and that is this: that if you have a bunch of quote-unquote weapon parts that includes a frame or receiver, then guess what? It's already a firearm, because the relevant federal statute says that if a frame or receiver is in and of itself a firearm under federal law. So if you got a weapon parts kit that includes an already completed frame or receiver as a frame or receiver, that is a firearm that has to be serialized, and it's a firearm. But of course, if you just have parts that could ultimately give rise to a frame or receiver, that is not going to be enough. And again, the ATF is trying to draw the standard to say if there's a series of parts that when combined with an expert set of hands in a working workshop and an 8-hour workday, like we saw in the Larry Smith case from 1973, they're basically saying that gives rise to a firearm under that scenario. And it seems to me the court thinks that they're kind of being absurd about this to put that standard to ordinary Americans, that if you're Michelangelo with a slab of marble, you can give rise to David, but if you give me a slab that somehow I'm the owner of the statue of David because I have a marble slab, that is absurd, and I think the court recognizes that stuff, and I suspect that analysis is going to find its way into the opinion. The last thing I will say on the remedy as to what the court will do, there was a little bit back and forth about whether or not vacatur, if entered, is appropriate, and if so, would it apply to the whole country and to everyone in America? The answer seems to be yes. There was also a little bit of reference to like the possibility of an injunction that applied only to the parties in this case. That was a little bit back and forth about that. But again, I think that is something that's going to pop up down the road. But for now, the issue really is, I think there's going to be a decision against the ATF in a huge way. They're going to enter an order of vacatur, but in the short run, it's not going to matter because, as I mentioned earlier, the Supreme Court has already said that orders of vacatur are stayed pending really resolution by the Supreme Court. And if I'm Merrick Garland, who's a very political animal and very smart, he may not be someone we like as the Attorney General because he's on the other side of every single political issue that we confront. But nevertheless, he's very smart. He recognizes that a vacatur order enjoining or stopping this regulation from going into effect is going to, the stay is going to remain in effect for well over a year, and he can slow roll any request to the Supreme Court to hear the case by cert, and that is what he will do, which means basically that this ghost gun regulation, at least when it comes to vacatur, will likely remain in place through the 2024 presidential election, no matter what the Fifth Circuit does, although there is a possible workaround or angle about that, which we can talk about in a future video, but I don't want to get too geeky about that remedy right now. I don't think it's worth getting into for the moment. I think right now we should focus on whether or not the Fifth Circuit is going to enter the remedy of vacatur, which wipes out the regulation for everyone in America. All right, folks, hope you learned a little bit something here today. By the way, I live tweeted it, so if you haven't followed me on Twitter or X, at 4 Boxes Diner is the handle. And again, we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.